matter for correction, my lord. There is a very small correction, my lord. Uh, there, the petitioner is from South 24 Pargana and the order printed not 24 Pargana, my lord. I have already corrected the order, my lord, and
Give it will appear for correction.
In this matter, on several occasions I have mentioned this is an old hearing matter, Lordship. That issue
Hearing
has been
matter, please wait. There are a lot of
Lordship,
hearing matters I have not
no,
been
no,
able to catch.
Lordship, issue has been decided because this honorable court division makes, Lordship.
Very well.
Your lordship may be permitted to mention fee transfer applications that are pending from 2022 motion stage. Grateful, your lordship.
Lordship, may I permitted to mention some matter? Your Lordship, my prayer is also same. There are some transfer matters which are pending from the 2022, Your Lordship. I'm mentioning for inclusion, Your Lordship. Grateful, Your Lordship.
My lord, may we complete to mention, my lord, two matters, my lord. One is motion, another hearing. Group two matters, my lord.
Motion give. Hearing, I already have a lot of matters. It will only get added, but let me finish some matters, then I'll take.
No, let the matter be listed, my lord. If my
You
luck
give this
favors,
slip, I have not allowed anybody. So you give this slip. Let us see next week.
kind, I'm grateful, my lord. I'm giving the slip, my lord.
কল করুন ওয়ান থেকে কল করুন নোটিফিকেশন দিয়েছেন না দেননি এখনো বাইরে দিয়ে দিয়েছেন মানে পাবলিশ হয়নি এখনো ওয়েবসাইটে কেন হবে না 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 ওয়েবসাইটে পাবলিশ হয় তো হবে না আবার কি জিনিস হয়তো আমি দেখেছি হয় কি কারেকশন আছে সাপ্লিমেন্টারি কি নোটিশ তো দিতে হবে সাপ্লিমেন্টারি আবার কে বলেছে সাপ্লিমেন্টারি
A bar announcement may also help the members.
bar announcement will be there but it should be there on the website also why will it not be there এটা কি জিনিস শুনছি যে হচ্ছে না আমি তো বারবার দেখেছি হয় আপনি কল করুন ও বলে গেলে তো হবে না আপনি কল করুন যা হবে আমার সামনে হবে আপনাকে বলে গেলে হবে পাস্ট ওভার পাস্ট ওভার
5, 6, 7, 5, 8, 11.
I am for the petition in this matter, my lord. Lord, since the other side is not, let it be passed over for the moment.
পাস্ট ওভার unnecessary wastage of time because of misprinting in the list this is so distressing
Yes, it cause inconvenience to the advocates.
আপনি সন্ধ্যাবেলা একবার দেখিয়ে নেবেন যে যা হোক নিজের করে টাইপ করে দেবেন না নিজে থেকে যা একটু লিখে দিলেন লিস্ট উইল বি কলড অন
Item number 30.
কল করুন থেমে যাওয়ার কিছু নেই কল করে যান হ্যাঁ কল করুন
Item number 56.
না 16 অবধি থেমে গেলেন কেন 17 করে করুন 56 করুন হ্যাঁ
20, 18, 19,
না এবার 35 কি আবার 56 থেকে কল করবে।
File time for the petition.
Item number 10, 11.
ফার্স্ট ওভার করতে বললো তো।
No, she is addressing item number 11 and 10.
Yes.
What happened? Well, 56 time for the petitioner, my lord. My lord, last occasion, my lord. Well, it is that matter, my lord, of the order, my lord, which was passed on
Who is
consent.
waiting for the
Yeah.
state? Let them come.
I have informed him, my lord, yesterday also and today morning also, but
They are passed over.
আলাদা কথা।
15 mile on short pass over.
Passed over.
I'm for the petition, Lord.
Go for the
I'm for the petition.
দেখি
I'm a retired teacher.
you had said on the last occasion that there are chances of your grievances being
Yes.
redressed. They have been settled.
No, nothing done.
Then you have to serve a notice because on your representation I said that
I supplied them all papers they requested me to supply on 12th June 25.
I'm passing it over. Let your respondent come. Pass over করো। Passed over.
61 minute appearance they have to respond. The petitioner has got certificate and mark sheets. This is the main grievance before your lordship. Take the lordship. First letter written in Bengali, where is the acknowledgement, the bottom corner, that mark sheet bujha paila. And the next page is the DI has written to the court so that the petitioner may get certificate.
Can you call this gentleman, the learned advocate? If you can call him, his mobile number is there at the back of the petition. Then I can dispose this of.
I'm just go outside.
Yes, yes. Numberটা দিয়ে দিন call করুন।
I have my lord.
You have. Call him saying that court
Lordship.
is waiting for you.
Lordship.
এটা
Short pass over.
ওর সঙ্গেই রাখুন। Passed over.
কে আছে? সুমন। It was heard by your lordships.
Yes.
Not satisfied. The PG scale was allowed to draw as I am an honors category candidate and with the permission of the ADI. And after retirement, page 24, P4 is the subject matter of the challenge.
অবজেকশন আমি লিখেছি কেন কবে ডেটটা দিয়েছে অবজেকশন রেজিস্টার 29/12/2020
Before your lordship got,
Yes.
now your lordship kindly, column 9. When the pension paper were processed after retirement,
PG scale allowed, but
the
this order
PG
is
scale,
applicable only for SSC.
1595, but this order is applicable to SSC teachers only to justify. Now your lordship kindly see the permission was, I was a honors candidate. My appointment of approval was recorded, page 19, page 19.
Page 19.
Page 19 is the approval memo, wherein the honors category was recorded. Thereafter, my lord, the permission was given by the concerned authority, page 21. The undersigned has to inform him that the Govind Chakravarti has been allowed to enhance his qualification in MSc Math in terms of the resolution of the managing committee from Rathaishu Open University in academic session to 2003-2004 without hampering his normal duties. Now, madam, the permission, after the permission, madam, postgraduate scale of pay was given. Page 23, if you lordship kindly.
Yes.
Postgraduate scale of pay is hereby accorded in favor of Sri Govind Chakravarti, BSc Honours in Mathematics, BT, with effect from 1/1/2007. The day next following the last date of examination in terms of the GO number 1595 of the dated 26/12/2005 in the relevant subject to his appointment. Now, my lord, I was drawing, and till my retirement I draw. After retire, I retired from the service on 31st August 2020. Lordship got it. 31st August 2020, I retired from the service.
Where
And
do I
this
get that?
objection was raised on 29/12/2020.
Where is the document of your retirement?
Document of the retirement, my lord, I have,
Where have you mentioned?
I have mentioned the paragraph 5, if the lordship kindly takes trouble to go through paragraph 5. Having rendered continuous service of 31 years on attaining the age of superannuation, your petitioner retired from her service in the capacity of the assistant teacher with effect from 31st/8/2020. And 7, para 7, the pension papers of the petitioner are submitted with the office of the district for schools, and the deputy director of accounts raised certain irregularity in the pension of the file as regards the admissibility of the postgraduate scale of pay. Such objection was raised on 29/12/2020, which is after retirement of the petitioner. There twofold prayer I am making. One, in terms of the rules, as I am an honors candidate, I am entitled to have the benefit. And secondly, and with the permission of the district.
Which is the rule?
My lord, the 1595 টা দাও না। না, control expenditure একটা এই the, my lord, the 2005 rule says that it has been made to appear the governor that the appointment of the honors graduate or a postgraduate category honors degree or postgraduate is an essential qualification. Whereas for selection of the appointments of the honors graduate or postgraduate teacher category, the honors degree candidate will have to compete with the postgraduate degree candidates on the same syllabus and same set of question papers in the examination conducted by the school service commissions. Now, my lord, it says such teachers after
But
joining,
Mr. Bari, is it not so that at when were you appointed?
I was appointed 95.
So at the time of your appointment, the rule that was prevailing, that will apply to you.
Yes, madam, that honors scale of pay in the 1998 local rules, there was no categorization. The teachers appointed with the higher qualification or teacher improve or will improve with the subject relevant to their subject and prove is entitled to have the benefit in terms of the Roman 99. So, similarly, in 2007, when the Service Commission Act came into force, the certain manner Control Expenditure Act came into existence. The Control Expenditure Act is that speaks about the appointment through the Service Commission. But the principle laid down, if a teacher honors category teachers appointed by the Service Commission and one of the following procedures improve his qualification, he is entitled to have that benefit. And pass that category teachers, that is, your lordship knows that the Uttar Kanti graduate, the special graduate have been delivered. The first category, they are not entitled. But the honors category, at whatever means, within the relevant subject and group, they are entitled to have that benefit. Now, madam, the Control Expenditure Act C, I'm handing over to your lordship after.
Report in
The report, it has been annexed, your lordship.
Report?
The report, your lordship, got?
Yes,
The report in the form of affidavit.
yes.
Page 4.
Page 4, yes.
1595, they have annexed. Now, therefore, your lordship can be 1, 2, 3, 4, 5.
Yes.
Fifth one.
In
Now
exercise of power.
In exercise of power, conferred subsection 14. In supersession of all previous order in the subject, the government is pleased to have specified with immediate effect that a teacher of the school who has been appointed through West Bengal Service Commission in the honors postgraduate category. Such teacher has a prior to joining the postgraduate in the subject relevant to the appointment.
But this according to them is applicable only to those those who have been appointed through the West Bengal School Service.
My humble submission would be the principle. Those teachers who is the honors, where is the bar? If I am honors qualified before Service Commission or before Control Expenditure, then the general rule will prevail.
No, but in that case, the Kolkanti Court's judgment says that prior to School Service Commission, the law which was prevailing, that will apply.
Yes.
It says so.
Then my Rupa rules will apply.
Yes.
1990.
2004
If matter
2003-4 session. 2003-4 session.
2003-4 session I have completed. So
It says that enhancement of pay on acquisition of higher qualification during service career is dependent on the relevant rules operating at the time of acquisition of higher qualification. So at the time when I obtained honors, at that time the rule which was prevailing, that will apply.
Yes, in 2004, before we School Control Expenditure Act, 2004 I improved my qualifications. So 2004, if I improve my qualification, 98 Rupa was operating in the field. Well, what 98 Rupa says, clause 12.3, all teachers, including physical education teachers, librarians, schools who have improved or will improve their qualifications, who are appointed with higher qualification in the subject and group relevant to their teaching and appointment shall get higher pay scale appropriate to their qualification with effect from 1st January 1996 or the date including such qualification whichever is later. So show me the years.
Right.
12.3.
No, but honors degree, will it amount to higher qualification?
Honors qualifications is the qualification, and I improve my qualification.
You obtained masters.
Masters in the relevant subject as well as
In which year? 2004 you.
Before Control Expenditure Act.
So before that there was another rule also. There was another.
735 was there, but the 735 speaks about the School Service Commission.
So this will apply.
And the principle, what is the principle? If I improve my qualification as a honors category, obtaining complying all formalities, I am entitled to have that benefit. either by the School Service Commission or by the Ropa 90. Nowhere I have not seen that there is a bar, there is a restriction that the honors category teachers should not get the higher certificate.
This is 1999. The circular is dated 1999.
Yes.
The one which you showed?
Ropa 98. Ropa 98.
No, but it forms part of a memorandum dated 12th February 1999.
Yes.
25 SCB.
25 basic.
25
Yes,
SCB, yes.
25 basic. And moreover, madam, in terms of the Rofi mercy, they cannot cut it. They
Yes.
cannot cut after it.
Yes, sir.
Problem lies is allowing his higher scale as page 23, putting the wrong provision, which is not applicable already.
Question is whether he is entitled to or not, and whether they have power to grant or not. If under one provision they have power, the exercise of power will be validated under that provision.
And after returning, it has been only detected by the office of
So
the
in
Director.
in terms of Rafiq Masih, you cannot ask for refund. And what is Mr. Bari's prayer?
Madam, my prayer,
Your arrear pension and all
you can
pension has been
cancel and
stopped.
withdraw the impugned observation P4. Further directs the respondents to disburse the
Your
due.
pension has not been paid. It has
No,
been stopped.
nothing. I prayed for interest also. I don't know.
But Mr. Bari, on the last occasion you had handed up an order. There you were not, you had not asked for interest.
No.
It was not granted there.
No, madam, there was no prayer for interest. There was no prayer for interest in that. The specific prayer I have made here.
Very good. WPA 14042 of 2021 stands disposed of. এই যে এখানে দেওয়া আছে। তা ওনাকে ফেরত দিয়ে দেবে। আছে তো, এটা আছে এখানে সব হয়ে, হ্যাঁ ওটা ওনাকে ফেরত দিন। এটা ওনাকে দিয়ে দিন, কপি করবেন ওখানে। হ্যাঁ
ওটাই তো Your Lordship had the matter. It was continuing. Your Lordship asked for certain decisions in this regard which is available. On the other hand, was also relying some. Therefore, that matter, the one-page supplementary affidavit I have taken out in the Lordship kindly grant me.
What is the matter, Mr.
I
Bari?
tell you, Lordship. Well, the petitioner was appointed as a primary teacher. Now, my lord, after the appointment, this appointment was made in 2012. Now, my lord, the appointment of the petitioners was cancelled due to the direction of the Honorable Court, they said. Now, although there was no such direction. Now, my lord, the sum of the.
Oh, I recall. It is that matter, admissible benefits.
Yes.
I have recalled.
Had the matter. Now, what has happened, my lord? The single judge of this court directed this order. I have relied, my lord, the place before your lordships on earlier occasions. It will be clear, page 37.
Yes, yes, I remember. Yes, Mr.
Now I shall be relying. I shall be relying for judgment thereafter my time. I will conclude myself. Now the question is there, when my termination was set aside, an appeal was preferred, and the appeal dismissed, section 5 application itself was dismissed, and order of the single judge was confirmed. Whether they can raise it further. Secondly, my lord, the seniority continuity was directed to be given. Whether they can issue a further appointment letter from 2020. Now their contention was a bunch of writ petitions. 2 writ petitions filed and my lord, an appeal was taken out. The appeal court said the notional fixation will be there. But my writ petition, the independent appeal was also taken out. That appeal was dismissed. That means one of the order of the single judge become final. That has got no application in my case. Thirdly, the lordship's query was whether my lord I am entitled to have the back wages. Continuity, emotional fixation, not only whether I am entitled to back wages. My humble submission to the lordships for wrongful terminations. If it is said it is the wrongful terminations, I am entitled to have that back wages. Well, that authority I have addressing one after another. মানে দেখ এটা দাও 13 থেকে দাও। Madam, this is the judgment reported in 2013 from 10 Supreme Court cases. Case 3 to 4. There are 22 and 38. 2013, volume 8, SCC, page 3 to 4. Para 22 and para 38. Para 22 के losses can be. The very idea of restoring an employee of the position which he held before dismissal or removal or termination of the service implies that the
Para?
para 22.
Para 22.
Case 344.
Para 22. Yes.
That very idea, restoring an employee to the position which he held before dismissal or removal or termination of the service, implies that the employee will be put in the same position in which he would have been put for the illegal action taken by the employer. The injury suffered by a person which is dismissed or removed or otherwise terminated from the service cannot easily be measured in terms of money. With the passing of an order which has the effect serving the employer-employee relationship, the latter source of income gets dried up. Not only the employee concerned, but his entire family suffers grave adversity. They are the deprived of the source of the sustenance. The children are deprived for books and all opportunities of education and the advancement in life. At time of the family has no borrow from the relatives and other acquaintances to avoid starvation. His sufferings continue till the competent adjudicatory forum decides on the legality of the action taken by the employer. The reinstatement of such an employee which is preceded by a findings of the competent judicial body or a court that the action taken by the employee is ultra-virus the relevant statutory provisions or the principle of natural justice entitles the employee to claim full back wages. If the employer wants to deny back wages to the employee or contest his entitlement to get consequential benefits, then it is for him and her to specify plead and prove that during the
This is what I was also.
That's why I use that supplementary. That's why that employee.
No, it is for the employer to use.
Yes, but what I have said categorically by filing supplementary, I was not employed.
On the first day only, I told this to Mr. Chattopadhyay that you have to establish this.
And that source, my lord, I wanted to search and I advised my client to file a supplementary affidavit to that effect, specific paragraphs that I was not gainfully employed at the time of that. My lord, I have made that. The denial of the back wages to an employee who has suffered due to an illegal act of the employer would amount to indirectly punishing the employee concerned and rewarding the employer by relieving him in the obligation to back wages, including the emoluments.
Yes, yes, I've read it.
Now, my lord, there are 38. The proposition which can be culled from the appointments and judgments are: in case of wrongful termination of the service, the reinstatement with continuity of the service and back wages is the normal. The aforesaid rule is subject to the rider that while deciding the issue back wages, the adjudicating authority or the court may take into consideration the length of the service of the employee workman and the nature of the misconduct of any found proof against the employee of the workman, the financial condition of the employer, and the similar other factors. Ordinarily, an employee and workman whose service are terminated who is desirous of the getting back wages is required to either plead it or at least make a statement before the adjudicating authority of the court. First instance, that she was not gainfully employed and was employed on lesser wages if the employee wants to avoid a payment of full back wages. Then it was plead and it was read present evidence to prove that the employee was gainfully employed and was getting wages equal to the wages he was employed prior to the termination of the service. This is so because it is settled law that the burden of the proof of the existence of a particular fact lies on the person who makes a positive argument about its existence. It is always easier to prove a positive fact than no proof of negative fact. Therefore, once the employee shows that he was not employed, the onus lies on the employer to specify the period and prove that the employee was gainfully employed and was getting the same similar. Now, this is settled law and Director Law. 2013, volume 11 Supreme Court cases. page 626.
अरे यार थोड़ा छाड़ू ना आगे ही छेड़े दिले
2013 volume 11 SCC, page 626, para 8 and 9. Having heard the learned counsel of the parties, we are constrained to observe. The High Court failed to examine the matter in detail and declined the relief to the appellant. In the fact, the aforesaid short order passed by the division bench would clearly show the High Court had not been acquainted with itself with the fact the appellant was kept out of service due to a mistake. He was not kept out of service on account of suspension as wrongly recorded by the High Court. The conclusive is therefore obvious that the appellant could not have been decided the benefit to back wages on the ground that he had not worked for a period when he was illegally kept out of service. In our opinion, the appellant was entitled to be paid full back wages for the period he was kept out of service. Consequently, the appeal is allowed. The order passed by the division bench is was satisfied. The appellant has already been reinstated in service. The respondents are however directed to pay the appellant the entire full package from the period he was kept out of service till reinstatement.
না 14-15 এটা 2014 এটা
It is matter 2014 volume 15 SCC page 313 para 11 to 13. Volume 2014 volume 15 SCC page 313 para 11 to 13. Therefore, in the light of the decision of the court, Dipali Gonda cases, which was correctly relied upon the higher bench, decision of this court in Surendra Kumar Verma case, Hindustan Steel Works, I am of the opinion that the appellant here is entitled to reinstatement with full back wages. Since the absence of the full back wages, the employee will be distressed and will suffer punishment for no fault of his own. The division bench of the High Court has clearly heard in law that the tribunal and the assembly have found the order of the termination is bad in law and for non-compliance with the above statutory provisions of the Act, and therefore the following normal rule of award reinstatement is awarded, but erroneously denies full back wages in the absence of the proof of the gainful employment in the appellant contract. And last, our division bench judgment. It is 1375 of 2006. It is also reported by the Indian Oil Corporation versus Bonaparte. November 22, 2007.
It is reported in CHN 2008 volume 1 CHN
2008 for 1.
778.
Paragraph 15, 16 and 29. We have already held that disciplinary authority had issued the punishment to the employee concerned, namely the respondent is petitioner without any valid reason. Even without appreciation, they directly declare findings of the inquiry officer as it is employer of the said employee had to suffer a serious prejudice. Therefore, we are of the opinion the case where the back wages should be denied should not be not a case where the back wages should be denied to the employee concerned of the respondent number 1 head. It has been repeatedly held by the Supreme Court that the payment of the wages is discretionary power which should be exercised upon considering the facts and circumstances of each case, and no rule of the universal application can be adopted. In the efforts and circumstances, we have no hesitation to hold then justice should be made if the responsible is allowed to back wages. These are my submissions. What has happened? I was one of the validly selected candidates. I was employed, I was appointed, I was drawing usually pension. By virtue of the wrong recording of my lord that they have said, then another possibility. The director of school education, my lord, remove us, 2-3 persons from the pen. Therefore, my lord, we have been denied our appointment and order of termination was there. I challenged the same and the court considered the same, court directed to the specific paragraph was that.
Yes, that I
Your
have seen.
Lordship said, yes. Now the
Yes,
question is,
Mr.
now
Chattopadhyay,
they have issued that.
you have got a copy
new
of the supplementary affidavit? Yes.
My lord, it is not a very simplistic case that the petitioner was, my lord, terminated by the whims of the respondent authority, our authority. It is a specific case of the petitioner that some person, my lord, filed a writ petition alleging that 5, my lord, appointment was done, they got lesser marks, my lord, than the, my lord, those petitioner. Accordingly, matter went up to the division bench, and division bench, my lord, directed the Commissioner of School Education to accommodate those persons, those who got higher marks than the appointed candidates. Accordingly, my lord, 3 candidates, appointment of 3 candidates were terminated in terms of the division bench order. My lord, thereafter they.
Where is the division bench?
Is 21, 22. Kindly have a look into my report.
Yes.
I have not annexed the order of the division bench, but I have annexed the order of the Commissioner of School Education. Wherein it has been indicated that in terms of the order passed in FMA 554 of 2015.
No, the order of division bench is there. Page 13.
Sorry, man. Sorry, man. I was reading that. Yes, my lord. Sorry, my lord. 554. Joydev Sardar and others, they challenged their appointment that they got lesser marks in spite of that they have been appointed.
No, Joydev Sardar was not appointed. Therefore, he challenged.
He challenged.
Because he was not appointed.
Joydev Sardar and others.
Saying that lesser people
we got higher marks.
People who got lesser marks than them were appointed, they were deprived.
My lord. My lord, page 16, there is a direction. Bottom portion, page 16. In the aforesaid circumstances, the respondent, including authorities of the district primary school council in Paraganas, are directed to take necessary steps for appointment of the appellant petitioner hearing as primary school teachers if the appointment petitioner were impaneled and secured marks above the cut-off marks secured by the last impaneled candidate who has already been appointed by the respondent council. Since a considerable time has already passed, the respondent authorities are directed to expedite the process of appointment of the appellant's petitioner, wherein in terms of this order show that the said appellant petitioners are appointed to the post of teacher in terms of this order at an early date and positively within a period of 6 weeks for communication. Needless to mention that the district director of school education, now commissioner, West Bengal, shall expedite the process of approval in respect of the appointment of the appellant's petitioner immediately after receiving the relevant papers and documents from the district primary school council Southwest Parganas. With the appropriate observation and direction, we set aside the impugned judgment and order under appeal and passed by the learned single judge and allow both the application as well as the appeal upon treating this said as this was direction. Accordingly, commissioner was directed to take decision, and accordingly Commissioner of School Education taken decision page 21 and 22. Bottom portion, three candidates: Joydev Sardar, Monimala Jana, Mary Mukherjee. For Bengali medium, next page, page 22. For Bengali medium, whose name were not included in the respective panel in connection with the recruitment process 2006. According to the merit of their names were sponsored by the employment exchange beyond cut-off date as per order of the Deputy Director of Employment Exchange such and such, in spite of having marks more than cut-off marks obtained by the last M panel unreserved category in Bengali medium in the approved panel. He has also mentioned in his letter under reference that there is no vacancy within the notified vacancies for such recruitment process to accommodate these three candidates. On the other hand, in terms of the Solomon order dated 6/8/15 passed by their lordship such and such, has selected the name of the petitioners under unreserved category in Bengali medium according to merits and send this directorate for according approval to their said selection for appointment to the post of primary school teachers for such recruitment process. If the name are inserted into the merit list as eligible and valid candidates as decided by the honorable court, and candidature of the three candidate unreserved category in Bengali medium appearing as third last, second last, and last candidate who have also received appointment will become invalid and ineligible as vacancies are fixed as per recruitment notification. Hence, appointment letter for the candidate are to be cancelled. In view of the above, he is requested to make necessary steps to issue appointment letter to the petitioner by cancelling the appointment of last three candidates under general category of Bengali medium of the approved panel after giving opportunity of hearing to the all the effective parties. This was a direction. Accordingly, their order was
But the
appointment letter
division bench did not say that you terminate
to accommodate.
to
Yes,
accommodate
yes.
does not mean that you terminate.
Because-
That has been held by the single bench.
Yes, because the observation of the Commissioner of School Education that it is selection in respect of the notified vacancy.
But that order has been held to be wrong by the honorable single judge.
Yes.
That
was-
order you cannot rely on. Commissioner's order has been held to be wrong.
What is the basis of their only I am trying to establish what is the basis in terms of the division bench order. We have taken reason that may be wrong. That was question.
So therefore it is a
Yes.
wrongful termination.
But thereafter, kindly come to the order of the contempt order passed in contempt proceedings by Honorable Justice Arijit Banerjee. Again, kindly come. My lord is stick on that point also. I will place another order day before yesterday. Similar matter was moved before the Honorable Justice Shogato Bhattacharya, and his lordship was pleased to observe that during that period petitioner did not work. He is not entitled to salary. He is entitled to notional benefit. Accordingly, this
In a
was
similar fact situation.
similar. Mr. Gaurav Das
The
appeared.
Supreme Court.
And Supreme Court, I will go through the judgment relied upon, but these all are disciplinary proceedings and termination. Wrong termination, accordingly, termination was set aside and he or petitioner was reinstated in service. Entitlement of back wages and would come. But here, my respect to submission before your lordship, what is the order of the of this honorable and single judge? That is order passed in contempt proceedings by the Honorable Justice Arijit Bandyopadhyay, wherein it has been specifically said that admissibility. And till date, respondent authority did not take any decision. Simply stated, what is their challenge? They have challenged in the writ petition the appointment letter issued by the primary council, showing that fresh appointment. That is the prayer that appointment letter should not be issued as fresh candidate. It will be a continuation of service. This is their cause of action.
Show me Justice Bhattacharya's order.
Yes. এই নাম্বারটা না গৌরবের কাছে
Then how do you deal with the judgments of the Honorable Supreme Court?
My lord, I will
Paragraph
certainly, I will.
Paragraph 5, your lordship can be judged. Paragraph 5. In terms of the order dated such and such, whereas Chairman Justice Chavusona, the petitioner joined the post of primary 10 July. Petitioner prays for notional benefit. Here the petitioner prayer was for notional fixation. I have not prayed for notional fixation.
No. The name, my lord, it is indicated.
They have also prayed for arrears.
Whatever it
Paragraph
is.
6 also prayed for
Yes.
arrears. Prayed for release of arrears.
And so here, my lord, same prayer made in paragraph number prayer A for set aside of the appointment issued by the council
And
and
if the
to release
Supreme Court
all
decides the
area
issue
salaries.
of the-
My lord, I will certainly, I will, my lord, I will try to distinguish with the judgment. My lord, this is not applicable in the case of petitioner. My lord, again, my lord, kindly come the order of Justice Banerjee, page 31 and 32. Because appeal was dismissed, thereafter one recalling application is still pending, and my lord, the order passed in contempt procedure, it has been recorded that subject to the final decision of the restoration application.
What's the restoration? Your lordship kindly go through whether it is a
My lord,
restoration
my lord,
application.
page 32.
Your lordship kindly
আচ্ছা দাদা এবার আমি বলে নি আপনি উত্তর
না,
দিন।
না।
প্লিজ আমি বলে নি তাহলে আপনি বলুন আমি বসে যাচ্ছি
restoration to not.
বা আপনি করলে হবে আপনি
না, ঠিক আছে, ঠিক আছে। Your lordship kindly have a look to the whether it is a restoration application. Page 44. Of the petition.
44.
44.
44 of
Read petition. Have you got it?
'44.
Yes. This is an application for condonation of the deed filing the present appeal. The period of deed is considered which is more than 9 months. Even if the petitioner claims there has not been any negligence on their part within the appeal, the application does not reflect any such diligence with which ought to have been pursued their remedies after the interim judgment had been delivered by the Rani Singh judge. The explanation sought to be given by the petitioner does not appear to be convincing. We decline to condone the delay of the filing appeal. Application under Section 5 of the Limitation Act is also dismissed. Since the application for condonation of the delay is dismissed, the appeal has not been allowed. The appeal being amended number as barred by limitation. It is the order on merit. It is not the order for dismiss for default.
Is it, my lord, my lord, again I am asking question myself with my lord, regard to the submission made, advanced by my senior friend, but whether it is my lord, appeal is dismissed on merit. This is very my lord, on technical point. It was my lord, again my lord, kindly come to page 32, 31 or 32.
Yes.
My lord, I think my lord, 32 second paragraph would I have noted the aforesaid submission. The facts remains that the order passed by this court on 13 July 2017, about 2.5 years have elapsed, but the order has not been complied with. Although there is no interference with the order of the higher forum, an order of the court, so long as it stands, must comply with the otherwise there will be no rule of law. I died. Kindly come. The alleged contemner to comply with this court direction in the order dated 30 July 2017 by accommodating the petitioner in whatever manner they deem it fit and proper, and if necessary by creating supernumerary post and issue appointment letter to the petitioner, making it clear that such appointments will be subject to all order that may be passed in appeal that stand dismissed and for restoration of which application is pending. Such appointment letter must be issued. Kindly come to page 7, subpara 8 of my report. Page 7. 8. 7 is by an order dated 19/3/19, the division bench dismissed the was pleased to dismiss the appeal as barred by limitation. Thereafter, I filed recalling application. That the said order dated 19/3/19 of the honorable division bench High Court Calcutta has already been recalled by filing application for recall being CAN 66669 of 2019 on 15/7/2019, which is still pending before the division bench. My lord, I am putting question myself. If I succeed in that, my lord, contempt application, and if I am ultimately succeed in appeal, then what would be the fate of the, my lord, order passed relied upon by the petitioner? And the contempt order is, my lord, it reflects that appointments shall subject to the decision of the restoration application. So till date that application is pending. So what is the, my lord, cause of action till pendency of the, my lord, restoration application before the division bench? He would get all, my lord, benefits, my lord, which is under challenge. That is my respectful submission. And my lord, this is, my lord, very vital. Unless this application is dismissed or allowed, so, my lord, my respectful submission, this court do not have any jurisdiction to deal with the entire, my lord, facts. But because that order is under challenge before the appellate court, appeal is not being dismissed with on its merit. And, my lord, here the Alauddin, my lord, case of Alauddin, because Alauddin is the first, my lord, appellant whose appeal was succeeded, and, my lord, order passed in appeal court, whereby direction was upon the, my lord, Commissioner of School Education to take a decision. Accordingly, my lord, page 35 of my report, that Commissioner of School Education, sorry, my lord, Alauddin Mullah and Bapi Sarkar, not appeal, my lord, they filed one writ petition, and in terms of the order passed of the, my lord, learned single judge, the Commissioner of School Education, my lord, passed an order with respect to particular two persons, my lord, teachers, Alauddin Mullah and Bapi Sarkar. But till date, the case of the, my lord, Shikha Manna petitioner hearing before has not been considered by the Commissioner of School Education, because Commissioner of School Education has given, my lord, notional benefit. Why? Because unless until my lord, the appeal is being decided finally, we are not in a position to give any further benefit. We have taken a policy decision that those three candidates have been terminated. They are entitled to notional benefit. But in respect of Shikha Manna, no opportunity was there upon the Commissioner of School Education to take a decision. In spite of that, it is a stand of the Commissioner.
These against the orders passed in the case of Alauddin Mullah and Bapi Sarkar, state did not prefer appeal.
Yes.
My lord, I shall place on.
Some, because some records are lying with the, my lord, district primary school council. Let him submit, my lord, in support, or, my lord.
And what about the judgments of the Supreme Court?
Supreme Court, I have, my lord, I will refer one judgment wherein, my lord, it has been specifically held the learned single judge, an employee was transferred from one place to another place. He did not join. In the meantime, he was superannuated. Accordingly, my lord, learned single judge directed the respondent authority that to give all benefit, including salary. No work, no pay, that was not taken into consideration. That went up to the Supreme Court. Supreme Court wanted to hold that learned trial judge, before deciding the issue, did not give any opportunity to the appellant's company, respondent's company, to take a decision. Similar to the present case, that we have not taken a decision with regard to Shikha Manna. We have taken decision to other persons.
No, but why? That is my question. Why have you not taken any decision?
Because that was not wound up. Simplicity, this writ petition was filed, challenging, no representation was pending before the Commissioner of School Education, no prayer, simplicity, challenging the appointment, fresh appointment, no prayer was there. Yes, I am entitled to get salary without any representation before any authority. They simply filed a writ petition challenging, questioning the appointment letter issued by the district.
There is a distinction, Mr. Bhattacharya. In this case, there is an order passed by the writ court asking you to pay admissible benefits.
Admissible.
Right. Now, so there is no scope for you to take any further decision over the writ court. You cannot sit in appeal over the writ court. The
Certainly.
writ court's order says
Certainly.
that you give him admissible benefits.
Certainly.
Now, if you say that those are not admissible benefits, then you say it here before the court. What further decision will you take?
My respectful submission, that order is also under challenge. That appeal has not been decided.
It cannot be under challenge for 1 century. Since 2019, why have you not taken steps to get your can heard? You will keep it pending and you will obviate any step to for the employee. This is malafide.
So out of court, I am not advocate record that here. Only the report affirmed by the commissioner, where from it appears that one candidate is pending. My respectful
But the
submission
commissioner,
also,
then you are
it is also
representing the
due to
commissioner.
because he is
You are
suffering
also representing the commissioner.
Yes.
So why don't you advise him
it
to
is-
get that heard? What is the
It
use
is
of
also
getting
duty
it
of the
pending?
petitioner. He is prejudiced with the pendency of that application. They may bring that application before the.
No copy has been served, nothing else, only making an application.
But my
It is a
report against my
restoration
report,
application.
no exception has been filed.
What exception? The
So
restoration.
paragraph number 8, I have categorically stated that since during pendency of that application, commissioner is not in a position to take decision. He did not file
What
any
about the
exception.
Supreme Court judgments which Mr. Bari
Yes,
has
yes.
given?
And my learned friend possibly has not gone through the brief. Page 47 is the decision of the the chairman, District Primary School Council issuing fresh appointment.
Yes, no, I am not saying anything with
47.
regard to decision of the
Your Lordship,
council.
see page
Only state
47.
authorities are representing state
After
authorities.
the order, they have issued a fresh appointment.
Yes, that is.
I have challenged.
Yes, that
So no decision. is
I
taken
think my
to not
learned
challenge.
senior could not follow my submission also. That is also my lord bad luck.
That is the bad luck.
That is bad luck. My lord. Could not follow my lord.
How could I follow?
I am small advocate.
That's why I am not following you.
So my lord, my respect to submission, unless this, this is good. And my lord, if you lordship, I have my lord, bring one order, my lord, judgment of Supreme Court, my lord, wherein my lord, specifically Supreme Court observes since the authority did not take any decision, so matter relegated to the authority to take a further decision.
I'll come back in 5 minutes.
My lord, or my lord, give opportunity.
5 minutes. I'm free. Yes.
My lord, my learned senior friend relied 4 judgment, 3 Supreme Court, 1. My lord, go through with the judgments.
Very good. So if you want to go through, if you want to take exception to the supplementary, you take this also
I will.
in the meantime. লিখে নিন।
বল না কিছু।
হ্যাঁ সাপ্লিমেন্টারি থাকবে, সবই থাকবে।
ইন্দ্রজিৎ মুখ খুলছেন। জজমেন্ট দিয়েছি আমরা।
Who said Prashad was appearing for the other side?
If you can get him, ask him to come.
বলো
Fast over.
আজকে আছে তারপরে চল কিছু কোনটা
Honorable statement. That pertains to postgraduate scale of pay of a teacher appointed in a honors category. After joining the post, the concerned teacher, with the permission of the managing committee, with the competent authority, not acquired the postgraduate scale of the year 2017. Now, issue was there that the initial order passed by Manager Sarah directing the authority to take a decision. The authority took a decision on the plea regarding prior permission from the DI in terms of the executive notice circular 593/2007 was in vogue, subsequently diluted by the honorable larger bench that if the competent authority being the school authority granted prior permission by virtue of the executive instruction or executive order, the initial control of expenditure rule cannot be diluted. So therefore, managing committee is the competent authority to give permission for the post for the purpose of granting postgraduate scale of. Now, when in course of the hearing of the case, my learned brother took the additional point, not in the impugned order, beyond that since I acquired the postgraduate degree after the Amendment Act of Control of Expenditure Act 2005 in the year 2017, I persuaded from the 2015 to 2017. Now, since I got the result of final publication of part 2 after that promulgation of amendment, So therefore, I am not entitled. That is the issue. So I have brought those that notification as well as under what circumstances this amendment came into force, and the recruitment process there on 2016, and the bill also of 2016 I have somehow collected. Now kindly take the notes of some dates. Selection process of 2007 by the School Service Commission. And this point also decided by the coordinate bench also. Taking that plea of particular DI of Murshidabad, same plea was taken. And the Honorable Court turned down that plea itself, directing the, I have that judgment. But selection process of 2007, petitioner joined the post as an honors graduate in English subject 27/9/2008. After the control of expenditure 2005. Now, he made an application before the concerned school authorities on 10/4/2015. This is my first application for pursuing my course. 10/4/2015. These dates are right. Join the post in a honors graduate category, English subject, on 27/9/2008.
Yes.
Now I made an application for enhancement of my qualification to the managing committee 10/4/2015. That is the cause of action arose for enhancing my qualification. Managing committee by resolution dated, I am giving the date 7/8/2015. August 2015.
Yes.
Now I completed my course, that last date of examination 19/6/2017.
Yes.
My publication of the result 13/12/2007. Now, when I am placing the first control of expenditure act, and I had handed over the lists, and you will get that copy.
Yes, I have.
Branch, and I am giving another copy.
No, I have.
There.
Have.
That form you will also get from that document of this. Since 1993 till 2007, all these notifications, circulars, acts, rules. Not there, when I am handing over.
No, I may be having it.
Because it is relevant for the purpose of taking consideration, because since he has taken the plea of new amendment.
Yes.
What control of expenditure?
Yes, I have.
14 minus. I am on 14/3. 14/1, 14/2 is not applicable.
Yes.
14/3. Every teacher of a school shall, if appointed, the word appointed, in honors graduate or postgraduate teacher category, both, be entitled to draw pay of postgraduate scale of category upon acquiring postgraduate degree in the manner as may be specified by order. Now, if you'll also kindly take page 60 of the script. This is the manner, that means rule. 15 to
This is the order. This is the order prescribed.
prescribed at that material point of time of my appointment. Or may I read the entire?
I've read it. You read the relevant portion. I've read it number of times.
Well, first two paragraphs classified as manner for the purpose of act. Now I am on clause C. Well, A, B is not applicable. A with the postgraduate, B partial completion, and C is the my case. After joining, I persuaded from the beginning of the MSc course. Such teachers, after joining the post, improve his qualification with the permission of the authority. This is the grants. Competent to grant such permission, meaning thereby the management, shall, on being successful in the result of examination, after successful of the result of examination, theory and practical, for postgraduate degree in the subject relevant to his appointment, my appointment, be entitled to draw postgraduate teacher category from the next date of following the last date of examination. I result published December, then my entitlement revert back from the date of last date of examination, that is 19/6/2017. If I emerge from successful on December, then it will be revert back from the date of last date of examination. This is the rule. Now, kindly take the increment order at page 16. Second paragraph, the prior permission granted by the school admitted on 7/8/2015, and subsequently he passed MA in Part 2 examination and last date of said examination 19/6/2017. Now, taking recourse of the GO number 155 is 1990 Rupa's amendment. Whoever appointed to school service commission according to their qualification, that is. Now, after control of expenditure rules, submitting all these prior notification, since I am the post appointee of control of expenditure, my case should be governed by the control of expenditure. Therefore, 155 does not have to. Now, moreover, I will take the last but one paragraph. GO number 593, 27/11/2007, laid down the teacher is required to seek prior permission of the district inspector of school only when he and she wants claim additional or increment higher scale of obtaining the higher qualification through the management of the school. As this regard, therefore, by virtue of that executive order, it was there because at that point of time, no larger bench did not decide the issue. But I took this point first time before the honorable larger bench. Fortunately, I had the occasion to. Your Lordship, larger bench already gone through. Paragraph 179 onwards, it has been first 114 paragraph. Paragraph 114 starts with the curiously order dated. I shall go by the paragraph because my lord's page may not be there.
I have the code copy.
Code copy. Then take my 114 paragraph.
114.
114 first. It was dealing. And my I had
Curiously.
Curiously, order number 1595 dated 26 December 2005 was issued by the governor. This is the rule. In exercise of power under subsection 3 of section 14 of the Control of Expenditure Act 2005, and such order of governor is being modified by an executive order 593 dated such and such by a joint secretary, and it has not been officially gazetted. I had made an application through RTI, but it has been clarified by the department concerned. This
The submission which is being recorded.
This submission
What is the
for
finding?
mandate is number 179. Paragraph 170.
Yes.
Paragraph 170 deals with that is the executive order, therefore it cannot curtail the provision of 2005 rules. 179, 180. Conflict between the order and staff. Answer has been given to them.
Yes.
So that executive instruction cannot override this rule. Since the managing committee is competent, I have got the permission from this is. So far as the impugned part is concerned, impugned order is concerned, or subject to correction by your lordship already. This special bench already answered this question following that judgment of the coordinate bench I have got. After the special bench, it has been clarified. If I make an application before the managing committee, it is the duty of the managing committee to send or not to send in terms of this circular, even assuming my duty is conflict. So if the managing committee does not send it, so for that reason, the administrative communication, petitioner will not suffer for that. That ratio is clear also. I am placing this. Now, so far as the his contention in the report concern, my lord will see the report. It has been added to that effect beyond the impugned. Now, amendment for what? If your lordship sees column number 3, amendment of 14, I believe he has handed over second and third page of that report. Amendment of Control of Expenditure Act 2006. Yeah, it is for your lordship. What was the distinction from 2005 Act and 2016? My lord will be finding missing part is honors graduate category. Nowhere it has been mentioned honors graduate. See clause 4. C is for the graduate. Maybe for the first word.
No. I'm reading.
Amendment 3, subclause 3.
I'm reading.
I have checked it up from placing side by side to act.
So you are in which class? 11, 12?
No.
9, 10?
At that point of time, normal section. There was no classification in 2005 Act, normal section.
No, for which class you were?
No, up to 10. School was up to 10. Why it has come, I am facing fellows to remove your lordship query. Now, if your lordship sees that 4, I am coming within the amendment 4, I am not. Every teacher means appointed. Appointed means as on the date of coming into this amendment. Class 11 and 12 shall be entitled to draw postgraduate.
I have read it. Don't read it again.
Now,
next point.
There was no here. There is no honors graduate. Now, why it has come? I am to answer to your lordship. And this is has come into force with the appointed date, not 14th of September 2016. It has been notified by subsequent notification 14th of April 2007. This matter I can hand over to you, Lordship. And what is the amendment portion? Your Lordship will see by virtue of that which portion has been added to in the queue. This is the after amendment, this portion has come. Inserting those portions, this is the new dimension of this order of amendment. Now, why it has come? I am pressing. And your Lordship is required to take that appointed date. I have that copy itself also. Yeah, I have only one copy. You can take note of. New shape in that fashion of amendment. If I go by reading this, and which portion is changed, it is there. Substituted shall, all these things are there. And this, my lord, another point has amendment has been done by virtue of the NCT Act 2010 onwards. It is mentioned in the amendment also, bill, in the bill itself also. If I go by the bill of that amendment, take the bill itself for which reason it has come. Madam, kindly take that.
Please wait. First, please read. Let me read it and then.
Sorry, my lord. I apologize.
So it has simplified it, saying that if you are appointed in a graduate category, then in that case you will only be getting the pay meant for graduate category, no higher increment. If you are appointed in the postgraduate category, you will be getting pay meant for higher graduate category, no further increment.
No, up to 10, you will not, even if you are honors graduate or postgraduate.
Yes, in the category in which you are appointed, you will get only that
Only
pay. That
the
is the meaning.
Category, meaning thereby. Only past graduate. In this amendment, there is no provision for the honors graduate category appointed enhancement for postgraduate. And you see that what is not there. Only pass or post, no honors. And I have marked for paragraph number 4 of that.
No, it does not even say pass. It only says graduate.
Graduate means pass graduate.
No.
Honors graduate.
Graduate
also.
means an honors or pass graduate.
There
That
is
is
a-
why they have removed that.
That is why.
If they say graduate, that will include both honors or pass.
That
If
is
they
not
say
correct.
pass graduate, then it will exclude honors. If they say honors graduate, it will exclude pass. But if they say only graduate, then it will include both. That is the meaning.
That is the meaning, but honors word is not there. In
That is why they wanted to give away this anomaly. This anomaly they wanted to shed out.
Only graduate. Graduate means includes honors, subject to correction.
Yes.
Now, can I take the bill itself?
Yes.
For which reason it has come? On internal page 3. Statement, object, and reasons. I shall go by this.
Yes.
It is considered necessary to expedient and amend section 2 such and such of Control of Expenditure Act, and in conformity with the minimum educational qualification norms laid down under National Council of Teacher NCT Act. According to the NCT Act, in terms of Right to Education Act 2009, it has come. It was not there in 2005. When I shall be governed by 2005, even my appointment 2008. Now, column number 5. Column number 4, bill has been framed with the object and in view, and there is no financial implication of from the date of amendment, not in a retrospective manner.
Where do we get that?
Column number 5 of page 3.
Page 3.
There is no financial implication.
Yes.
It notifies this. Involved in giving the effect of provision of this bill. Effect should be given on the date of amendment, not the person who were appointed prior to the date of amendment. Their right cannot be cut by invoking the 11 and 12 clause. That is also not clarified. And if I go back again, paragraph, I believe 179 of the interpretation of the larger bench.
When did you get your degree?
17 June, or the last date.
Last date of examination,
And
19
December
June 2017.
2017.
19 June 2017.
And that is to prior to that completion part 1 complete, only part 2 after amendment. Part 2. Course of part 2.
Part 1 was complete when?
In the year 2016. 16, 15,
16
17.
when? 16 when? 16 when? When 16
Yes,
when?
I got the marks.
No, show that.
Yes,
Show that.
I'm showing. Partial completion. I'm giving the marks itself. June, 4th of June 2016 at page 45. And 45 is the schedule of part 2. Well, it got those 2 pages.
Page?
Page 40, 44. My examination schedule of part 1.
Page 44.
Last date of part 1 examination 4/6/2016. That is prior to amendment. Partially completed of the course. And page 45 is the date of last date of examination. My lord will get part 2.
Very well.
Now, my lord, if your lordship kindly again, my lord, take trouble of paragraph 179 in respect of that notification itself concerned.
Notification is not creating problem.
Yes.
Problem is created by the act.
Yes, I'm placing why that amendment has come. My lord, I'm placing. If your lordship go by again 179, the right claim of a higher scale of pay of any teacher. My lord, I'm reading second clause of that particular paragraph. With the honors graduate degree at the time of entry prior to such and such of December, it would be decided on the basis of guidelines circular existing on the date of its appointment. So therefore, my enhancement of scale will be governed from the date of my initial appointment, that is 2008. If I go by honors graduate, then I am entitled to in clause control of expenditure by the appointment, not any subsequent notification.
At the time of your appointment,
Yes.
you were appointed when? 2008.
27.
2008, what was this? Which was the circular which was binding you, which was governing you?
No, binding to the extent of prior permission from the DI. Now it has been diluted that no notification in respect of executive instruction, it is not required.
No, but the act itself was amended.
Yes,
That is
amended
the
in
problem.
2005.
So that the act itself was amended. You came after the act. You are governed by the Control and Expenditure
The
Act.
rules.
The act also. You are governed by the Act of
Act
2005 also, because your appointment is in 2008. Subsequent to the act, you are governed by the Control and Expenditure Act. If the act is amended
Yes.
prior to you having acquired the qualification, then in terms of, if you see the last page, paragraph 272.
272. On the,
272, what does it say?
it does.
That at the time of acquisition of qualification, the
Yes.
law which is prevailing, that will
that
govern.
will
So at the time of acquisition of qualification, the amended law was there.
subject to
So you will
correction.
be
or
bound by
something.
that.
Yes, subject to correction. I'm telling why this amendment has come. I shall please. Now, Adilujjaman says, if I pursue prior to any amendment of partial course,
Anirudh Jaman's case was again not one where the act was in consideration. It was considering the circular, not the act.
I mean, that
Act is binding. Act is binding. If your case was only circular, I would have understood.
all right.
Your case is not only circular, your
But
case is act
in-
also.
I
So
mean,
far
I
as
want-
2007
yes.
is concerned, we are not concerned with 2007 because it has been held that it will not have statutory force. But the act has statutory force. The act is amended, it gives it retrospective effect.
Now, yes, I'm placing why this amendment has come. I'm gonna take the 2016 recruitment rules. That is why this amendment has been invoked. In respect of 11, 12, then I shall place the 9, 10 as well as upper primary. This is in terms of the NCT rules. Second page, rules provides to are. This amendment I have shown the reason and object in terms of NCT rules. To are. Now I will kindly take last page of page 7. That is why that amendment came into force. This is the
Page 7.
Page 7, Schedule 1. Every appointment should be governed by Schedule 1, it has been mentioned. Rule 4, page 2, name, post and qualification age in terms of the Schedule 1. Well, got it, page 2, last but one paragraph.
Yes.
Under the NCT Act, now can you see the column number, schedule number 1? That recruitment for the post of 11, 12 only, meaning thereby control of expenditure act also says so. Only postgraduate with at least 50% of marks. There is no category of honors graduates. That is the purpose for amendment. Now B, postgraduate with at least 45 marks. C also postgraduate. So therefore, for the purpose of appointment of 11, 12, that is the date of notification 20th September 2016. Only the teacher who pursues to this selection process, their remuneration or salary will be governed by this amendment, because this amendment cannot have any retrospect. But I got that postgraduate degree after the new amendment came into force, but it relates back to my service in 2008. This is my interpretation of law. Now, if your lordship take the secondary portion, of this 2016 rule, notified on the very same date. Very same date in respect of, or I have
We have given this.
No, this is in respect of I have given prior to 11, 12, and now it is 9, 10.
No, you have given the same thing. Read it. Yes.
All right, madam.
You just now gave it.
Take that 9, 10.
9, 10 of what?
9, 10 of selection procedure of 2016. I have given initially 11, 12 portion. Teacher. Now all these teachers have been set aside by the Honorable Supreme Court. That's particular selection process. My lord, got it 11, 12? Or
9 is advertisement.
no, my lord, this is in respect of recruitment procedure.
Yes.
9, 10, dated 20th September.
2016.
16.
Yes.
Now your lordship kindly see rule 1.
Rule 1,
Schedule 1.
Schedule 1.
Yes.
Schedule
Teacher
1,
classes 9 and 10.
10 and 11. 11 and 12.
11, 12 just prior to. That is why I am placing. This is the for 9, 10. That is
देखिए
for 11, 12 I have got upper primary, 9, 10 and 11, 12. What was the qualification for being recruited and what?
So how is it material now? How because
Because
the act
for-
has said something.
Yes.
Now how we can read something into the act which the act itself has not said?
For the purpose of recruitment of 2016, this amendment of my postgraduate scale category has come only for this purpose I am saying.
But the act does not say so. How can you interpret? How can you put words in the mouth of the legislature? If the legislature itself has not said so, it will not
Now-
lie in the domain of the court to read something into the statute. We cannot read that. Whatever was in the mind of the legislature
It is my
has
interpretation.
no,
For
that I
reason it has
understand.
come.
But whatever has been spelled out by the legislature, only that is the law.
That is the law.
The
Now, if
intention of the legislature will have to be culled out from the reading of the statute only, not from these.
Now, if your lordship holds that if I completed my postgraduate qualification after the amendment, then I am not exempted in terms of subject to correction. This point already decided by this court. Answering this question.
Yes, show me that.
And this is from the DI Murshidabad division. Paragraph 9, 10, 14. Here, last examination, Melody will take page 2, third paragraph.
Page 2.
Page 2. That particular teacher, the last date of examination, later than my class.
Page 2.
Yes. Master degree course and completed the same, duly qualified. His last date of examination 29th of December 2019. That is after the amendment. Now, if your lordship take paragraph 9, this point was taken by the DI. Paragraph 8 onwards. Sorry, paragraph 10 onwards submission recorded. And internal page 6 onwards. Paragraph 14, why I know handed over that notifications of recruitment procedure that has been there. From there, I have learned. That is why I have placed.
But here he had been granted on a scale of pay, postgraduate scale of pay, he had already been granted.
Not, in my case, honors graduate scale I was enjoying. Not that I was enjoying honors graduate. Since after acquisition, I am entitled to from the date of following the date of birth. In terms of the interpretation of control of the future. Paragraph 15 is
15
clear.
this judgment.
No, ma'am.
Give a copy to him.
And that two other judgments are there. Regarding, I had another one other day regarding postgraduate qualification entitlement postgraduate scale. Raghunath Rai, 3 judgments already I cited. And if your lordship makes any query that if the school authority does not send, what will be the effect? That has been also answered by the Honorable.
That is there in the full bench also.
Yes, full bench also.
Full bench also has.
Following full bench. Following full
Full
bench.
bench also has said that.
But I realize those judgment after the full bench, if the honorable court either singly or division interprets the law of the judgment, I believe that will prevail in my case for interpretation.
No, full bench has said
Yes,
so
already.
clearly. So
Already.
no scope for
Already.
any
Managing
further.
committee is for prior permission is for absolute entitlement. Take it, can quickly into. And mother judgment also I have got from relying on those judgment also I have.
Paragraph 15 says that the amendment does not apply.
I shall distinguish this, my lord. I shall come back, my lord.
When?
Next week, my lord.
And same day, if your lordship.
But it has to
No,
be seen, my lord.
don't-
1
in
minute.
which, my lord, it has to be
Unnecessary,
seen
no.
in which class he has been appointed, 11, 12.
You
or
should have
16.
cited this judgment at the first instance. Then in that case, we would not have wasted this much of time.
But it is my duty to explain this
No, no,
in
cite
terms.
the judgment and finish. If he seeks time unnecessarily, then why should I hear?
I should have.
A report filed on behalf of
Lordship may kindly fix it on Friday, Lordship.
Then I'm making it not today, it will appear in due course. Not today. Not.
66.
Minor
68.
Procedural is appearing in this matter of Madras School Discussion 17 for the arts board matter. Kindly fix it on 24th of July.
Regarding my lord, only
What to do?
original answer script lying in the
Very well.
that the reopen that's my allegation is correct or not. That is the
Let
is
him
how-
come. Time is short for
Yes.
let him come. Don't oppose on that ground. When do you want?
24th of
Uh,
only answer script, original answer script, my lord. Interpolation or rewrite, my marks is reduced. Then that's why I'm not giving appointment. Deprived from appointment.
let him come. We'll pass orders in his presence. An adjournment is prayed for.
So on that date, my lord, it is চলে আসবে তো সেদিন হ্যাঁ
Okay. I am here for the future investment. It's a very short matter, madam. I'll say the key.
Guru. Answer.
Father of the petitioner was an assistant teacher of the school.
Service in terms of the last order.
একটা ছোট ব্রিজ মতো করতে we can reach our papers to you.
Nobody is appearing. Yes.
Well, the father of the petitioner was an assistant teacher of a school, my lord, who died in 1990. But the petitioner applied for appointment on compassionate ground. The prayer was allowed. School recommended the case of the petitioner for appointment as a Group C staff. But ultimately, at page 27 of the petition, there was a resolution taken by the school authority. Paragraph 6 and 7, the school resolution. I am covered by Shuklamal 7. বিদ্যালয়ের কর্মরত করণিক এবং কর্মরত
Paragraph 6 and 7.
yes of page 27. That is a resolution of the managing committee.
Yes. 6 and 7.
But by virtue of this resolution, the petitioner case was recommended by the school authority. That is the Shuklamal in the school. I was given appointment, but as
Group D staff.
Group D staff. But my qualification was commensurate with the
Group C.
groups. So prayer was made only for enlistment in the panel of Group C awaiting list for appointment on compassionate ground by rotation in the post of Group C. So long I should be continuing in Group D. But that particular prayer has been rejected by the authority. By the impugned order, page 35. Honorable Justice Nijamuddin was pleased to pass an order, third paragraph, directing
Consider.
to consider. But fourth paragraph, my lord, the writ petitioner was appointed as peon of the school on compassionate ground as her father, late so and so, died in 1999, while in service as an assistant teacher. At the material point of view, she was a student of class 9. Her prayer for compassionate appointment was considered by the authority, and accordingly she was appointed in the post of peon with effect from 1995. 95, my lord, I have already, my lord, acquired the qualification for the post of Group C staff. She claimed that she prayed to the DI of schools to enlist her name in the live register of appointment to the post of clerk, as by that time she passed Madhyamik Parikha, but she did not get any relief.
When did she pass Madhyamik?
Pardon, my lord?
When did she pass Madhyamik?
Madhyamik certificate has been already annexed at page 21. Right? She was higher secondary in
1995.
1995. And in 1993 board examination, he passed in Madhyamik. And page 18, my lord, will show. Yes. Delay ground has been taken, page 36, after a long gap on 1990. She made the representation to the TI to give appointment to the post of clerk, but she failed to produce a receipt copy of her representation. She was asked to provide record from the school authority in support of her claim that her name was forwarded for enlistment of her as clerk in the live register mentioned. She failed to produce any record for the same. A school was also directed to appear in the before the district inspector. The entire onus is shifted on me. I have annexed to your lordship the resolution copy. The issue is long pending one with the instruction of the school service commission.
Mr. Bhattacharya,
My lord.
I am recording this. You serve another notice on both the government pleader as well as the school. Let both of them come.
As your lordship. Right.
কখন হবে এরপর থেকে তো কল হয়
ঠিক আছে চেম্বারে দিন। কল করুন।
Line for the picture.
Your Lordship, Your Lordship, in this matter, Mr. Honorable Chattopadhyay is appearing behalf of the state, Your Lordship. He is in another court, Your Lordship, praying for only not today or pass over the matter.
Pass over. Passing it over.
Again,
Let him come.
it will be called at 2 or
2.
Last occasion, Your Lordship was pleased to consider the issue. There was a direction to file supplementary. Supplementary. Only the medical documents Your Lordship wanted to see, which I placed before Your Lordship. Just before that, my lord, I just give a short recapitulation of the matter. My lord, it is regarding transfer of the petitioner on self-medical ground. If Your Lordship kindly comes to page 76 of my writ petition. 76 of my writ petition.
Page 76. Yes.
My lord, kindly see, this is the transfer application through the portal. First, the application was made on 11th. Kindly take it from the bottom. 11th of December 2021, it has been made. Now, the last, then 13th of December. Ultimately, my lord, it has reached to the end of the DI. At the top, 19th of January 2022, DI rejects it on the ground. Not recommended as it is not under the 6 mentioned disease condition. That was the DI stand. First of all, DI has no power to recommend. Recommending authority is School Service Commission. DI cannot. Role of DI is that the process I had explained to Your Lordship. Again, I am just explaining.
No, I know.
Your Lordship
Please to
remembers.
take the advice of the
CMOH. Yeah, right. I'm so grateful to Your Lordship. Now, my lord, kindly come to page 34 for once.
Page 34.
Page 34. Bottom, rule 4.
Yes.
My lord, kindly take at the bottom, 4A. Any incumbent or his or son, daughter, spouse suffering from malignant disease, severe heart disease, renal failure, thalassemia, replacement of organ, serious gynecological disorder causing serious problem in attending the school. So if the incumbent is having serious gynecological disorder, she is eligible for transfer. So the very first submission for lordship that the DI said that no, your disease does not come under those 6 diseases is absolutely incorrect because she is suffering from serious gynecological problem. The next process which should have been followed, that since it has gone from the school to the DI sent it for CMOH, considering CMOH document, he should have sent it to the commission for taking the final decision. But he came as in between and saying that no, I will not recommend, though he is not the recommending authority, saying on a wrong perception that your disease, that is a serious gynecological disease, is not within those 6 diseases which I placed before your lordship. So his decision was absolutely erroneous. My lord, now kindly take the...
And where is that category of 6 diseases?
That I placed before right now. Just for page 34.
That ABCD.
No, page 34 bottom 4 serious gynecological problem. I placed.
No, it does not say 6 diseases. It says gynecological problems.
No, these are the 6 diseases. Kindly see. Serious.
Heart disease, renal
Yes,
failure,
these are 6. Yes, these are 6 in number.
Gynecological disorder is a broad category. It may have many diseases.
Yes, amongst the 6 diseases, serious heart disease, kidney disease, thalassemia, organ transplant, serious gynecological problem, and malignancy. These are the 6 category of diseases. Now, amongst which serious gynecological disease is one of the diseases. So, my lord, now kindly see the medical document, which I made RTI and got it through. What is the observation of the medical authority. My lord, may I just?
Yes, yes.
Yes.
1 minute.
My lord, kindly take the supplementary affidavit.
Yes.
I draw your lordship's kind attention to page 12 of my supplementary affidavit.
Page 12.
Yes. That after her medical verification, kindly see serial number 4 is the petitioner. Original medical examination report was sent to the CMOH after the medical board was conducted.
Yes.
Then, my lord, kindly come to the page 14. Page 14 is the report of medical examination in respect of the following person, which is held on 29th of December 2021. So this is the observation of the medical board: fibroid, this AOB.
So these are all the gynecological.
Gynecological problem. Kindly see, NOC may be issued with their complications, possibly, my lord. NOC may be issued, so the medical authority approves it. And also, my lord, page 15, prior stage CMOH is BMOH. BMOH also categorically holds that I'm suffering from these diseases.
Serious disease.
Serious disease. So, my lord, I qualify under Rule 4. The DI's observation is absolutely incorrect.
You think over it, I'm coming back.
Yes, my lord. Beautiful.
Team number 74, Mr. Kambaleswar applied for the petition is 2 p.m. on 5th.
Well, as I was
Yes.
appraising your lordship, that the contention that I place before your lordship is that
Yes,
DI
yes, yes, sir.
Millard, so far this supplementary affidavit is concerned, Millard, I'll take the appropriate instruction, Millard, from the concerned DI, Millard.
What? You were not served about with this. You did
Just
not serve
a
it.
few minutes ago.
My lord, these not few minutes, long back it has been served.
No, no.
Today itself,
Still, Millard.
But my lord, only one thing. This
After
is
entering into the courtroom.
my lord. First of all, my clerk wanted to contact him. He was not available.
Very well. How soon?
This is
7 days time.
No, don't take
open
7
and
days.
shut case,
Don't
my
take
lord.
7 days.
Nothing else.
Because he has only, in any case, the action of the DI is perverse.
Keep it on,
He had no business to return it to the school authorities without first taking into consideration the CMO's advice. That he is obliged to do in terms of the statute. If he has not done that, on that ground alone, I should strike it down. But since he has used a supplementary affidavit for the sake of compliance with principles of natural justice to make a show of compliance, because you don't have to say anything on this.
My lord.
You come back day after tomorrow.
Millard, Thursday.
Thursday after tomorrow is Thursday.
Millard, then keep it on Friday, Millard.
No, not Friday.
Thursday.
Friday.
No.
You said Thursday.
No, that's, he has nothing to say.
Monday you won't come. Nobody will come.
No, Monday is 21st July.
You are. So I will not fall in that trap. Thursday he has said.
Yes.
Thursday is a good day. Supplementary affidavit filed on behalf of the petitioner is taken on record. A copy thereof has already been made over to the learned advocate appearing for the response. In fact, I continued. It was mentioned from the bar that there is reciprocity. Please rise.
Yes, I know.
I had no mind to rise. I thought I'll complete.
It is for us.
But if bar takes this
And
stand,
last day lordship was in hurry. I understand that, but the difficulty.
you were not audible.
I was not audible because of the
I
technique.
could have taken up that matter. I had a
Yes.
mind to take that matter, but then you were not audible.
Audible. What can be done? The technical difficulties are still there. Technological issues. I'm grateful to.
Obliged.
হ্যাঁ পাস ওভার গুলো একটু কল করে দিন তো দুটোর সময় বলেছিলাম পাস
71.
না পেছন থেকে করো ওই গ্রুপ 2 এর অনেকগুলো পাস ওভার হয়েছিল না ওই 1 থেকে করো যদি কেউ আছে যদি কেউ আসে
73 আর
পাস ওভার ম্যাটার জ্বালিয়ে দিয়েছেন যখন কল করুন ফার্স্ট ওভার চলো কল করে যান चलो चलो চলুন কল করুন এবার 56
56, my lord. Electable for the state, my lord.
চলুন নেই
That
একদম
madam
নেই
Malda, Mr.
he was there in the morning আগে চলুন এগিয়ে চলুন এগিয়ে চলুন
I've got 50. Yes. My lord,
your other side is not there no he's there
no.
you serve a notice on them come back because without them being present I cannot pass an order. They serve a notice. On the last occasion Mr. Ranjan Saha appeared for the state.
He had been here in the first half. Ranjan Shaw is here. In the first half, I saw him.
I'm passing it over. If he comes back again, please inform. I'm not making it not today. Pass over করে রাখুন চলুন
And for the state, my lord, in this matter. 62.
চলুন চলুন চলুন
The last occasion I was directed to intimate the respondents. I have. I have.
all the respondents are there. Yes, what is your grievance?
My grievance very short matter. The petitioner is a para teacher in a school situated within the district of Howrah, Koratperia High School. In 2007, initially he was engaged. In 2015, his engagement was regularized by a communication dated 27th of May 2015, page 17.
Page 17.
Page 17, and it's a P1.
Page 17, yes.
This is the engagement letter issued by the district project officer, Sarvashikha Mission, Howrah. Like he was continuing with the service, but his misfortune in 2019 has happened, but he was implicated in a criminal case. Due to some political rivalry, a local person died. Rather, he was killed, unknown person, but he was also implicated as this present petitioner was implicated as the accused person. In connection with that case, he was arrested by police. He suffered judicial detention for 99 days. Thereafter, he was released on bail by the London Session Judge Howrah. After coming out from jail, my lord, he made a prayer before the authority concerned, considering his family situation, because depending on him, his parents, his wife and children are there. So he made a prayer before the authority concerned. Kindly permit me, my lord, permit me to continue with the state service. His prayer was turned down, my lord. Kindly come to page
20, 21.
21. Now, thereafter, I made, this is the refusal rejecting my prayer. Thereafter, I made representation page 22, followed by demand justice for reconsideration of my prayer. That was not done, challenging. That is why I am before your lordship.
Yes.
My lord, first thing, my lord, the appointment of the petitioner is totally contractual. Initial contract, my lord, was there for 1 year. Subsequently, my lord, he was allowed to continue up to 60 years. Contractual work.
Very well.
My lord, 1999, 2999, he was involved in a criminal case that is 302.
That he said, he's on bail, he has not been convicted as yet.
Yes, thereafter, he discontinued, continued to attain on 25th March 2019 till date. That he discontinued. Thereafter, he applied for presumption of his duty. That was negated since criminal case is pending. In the present case, there is no procedure for disciplinary proceedings because it's not a not relates to its service, it's relates to the criminal case. And the
No, if it does not relate to his service and it relates to the criminal case, if that is your argument, then why is he not being allowed to join?
I am submitting, there is a guideline framed by this honorable court. The Honorable Justice Rishtandon pass a judgment with a framing a guideline.
Sure.
I have that judgment. So, this is not covered the case of the prisoner. This
Then?
is the case where there is a misconduct. In that case, Lutfar Rahman case could cover. Guideline is last portion is internal.
But where is the misconduct? Misconduct has to be your finding.
No,
somebody's complaint has been taken cognizance of, and on that basis,
that is why I'm
criminal proceeding.
submitting. This is not the this guideline would not be applicable to the case of the prisoner. He is involved in a criminal case unless and until he has been acquitted from.
But is that the law? Law is not that. Law is that even if he is involved in a criminal case, till such time that he is convicted, unless he is indicted by the employer by way of a disciplinary proceeding or by way of a discharge from duties, he cannot be kept under suspension or a punishment of that nature for all times to come, till such time the criminal case reaches its conclusion. That is not the law.
This is in the case of contractual employment, there is no.
What are the terms of your employment? How is your employment governed?
That is the engagement letter, page 17. Your lordship will find. Then towards second paragraph. Then this engagement shall be valid until the age attainment of 60 years of the incumbent, who will receive as online one-time payment of gratuity of rupees 1 lakh if 10 years of service has been rendered by him or to Sarva Shiksha Mission.
No, as per existing norms and orders. What are the existing norms and orders? Those will govern the parties. It cannot be without any norm. Then it will be whimsical. If it is without norm that I am engaging a person, then tomorrow I will say your nose is not right, you go away. That can be a ground.
Pashchimbongo Samagro Shiksha Mission. This is the ultimate authority.
Very well, but all of them are to follow norms. If you see the first paragraph, last line, it says as per existing norms and order with effect from joining. Both of you are governed by some norms. Has to be. It can't be without norms.
I think Pashchimbongo Samagro Shiksha Mission is represented by Mr. Oishubri. He is representing the authority.
Stop them, let them come. And you also bring the norms so that this case can be decided.
Arjun Roy Mukherjee.
73.
This is my lord. Pertaining to the compassionate appointment in favor of married daughter. The rule says that for compassionate appointment, the family may include son, spouse, son, and daughter. But that the definition itself, my lord, if your lordship only kindly comes to the relevant provision of page 169 of the writ application itself.
169.
Yes. It is a part of my lord that 153, that is a rule of West Bengal School Service Commission, selection of person of appointment of post of non-teaching staff rule 2009.
Yes.
Under this provision for compassionate appointment has been made. Rule 20 is there, Rule 21, and after my lord, Schedule 5, it says about the procedure and manner of application and preparation of panel for appointment on compassionate.
Which rule are you reading?
My lord, 153 is the rule starting.
No, you said 169.
Yes, and the relevant portion relating to the compassionate appointment is 169.
So 169, which portion are you placing?
Yes, 169, my lord, Schedule 5. It says, my lord, the procedure, manner. Is a
Schedule
bold
5, where?
Schedule 5.
169 schedule.
169.
169, I don't have any schedule. Yes, Schedule 5.
Yes, yes, yes.
At the top.
At the top, my lord. It's pertaining to my lord, connected Rule 20 and 21. This procedure se okay. Reply. My lord, he says, when a teacher or non-teaching staff dies in harness before the date of his superannuation, that is the age of 60 years, leaving a family. My lord, it's my lord, here this is vital to be interpreted as leaving a family, which is in the opinion of the district inspector of school in such extreme financial hardship that it falls to provide 2 square meals and other essentials to the surviving member of the deceased teacher's family. It can be given to spouse, son, or daughter, either one. Here, the question comes whether this unmarried daughter can claim the benefit of this particular rule. When married daughter, my lord, after it has been categorically, my lord, considered by the DI at page 150.
Page?
150.
150.
150. May just skip the first paragraph, may start with second paragraph starting with submission of the petitioner.
Yes.
Is that late Vishnudev Mondol, the father of the rich petitioner, died on 19 while in service as AT of this school. Rimpa Ghosh, married daughter of deceased teacher, made an application to the chairman DPSC on this day for obtaining appointment as Group C employee of government-aided educational institution. Prior to this, she filed a writ application before the High Court at Calcutta, being sufficient for alleged pendency of her prayer. At the end of the respondent authority, the chairman DPSC passed a written order in compliance with Honorable High Court's order dated passed in 338 of 19. Same was communicated to all concerned VDMs of all relevant records associated with prayer for compassionate appointment of the petitioner was forwarded to the office of the district inspector of school, Bardwan by. Now, documents annexed with the claim of the petitioner are perused and found. The findings, my lord, date of death to the petitioner is the daughter of the deceased teacher, got married on 18th April 2011 as per certificate of registration under subsection 1 of section 8 of the Hindu Marriage Act 1955. So, my lord, prior to death, the daughter got married. So, she has come to my lord living with a different family. The petitioner Rimpa was executed an affidavit before Calcutta Judicial Magistrate at Durgapur on 8th of April 2019, wherein it is recorded that petitioner is residing at Biringi, Baruipur, Durgapur, district Paschim Bardhaman. The address of the petitioner as recorded in the epic of the petitioner is Biringi, Baruipara, Biringi, Durgapur. The petitioner passed HS 2012 and applied for appointment clerk of government dated on 29th. Now it is evident from the above noted documents that Rimpa Ghosh, daughter of the deceased, got married prior to death of her father, and since her marriage, she has been residing at her in-laws' house at Biringi, Durgapur under Paschim Bardhaman. The petitioner is expected to be an integral part of her in-laws' house, becomes a family member of her in-laws' family after marriage. Now the claim of Rimpa Ghosh has to be considered in accordance with the relevant rule being notification 697. That is, my lord, at page 153 and schedule 5. West Bengal Civil Service Commission selection person appointed of to the post of non-teaching staff rule 2009. As per Hindu Marriage Act, as amended from time to time, a married daughter is the legal heir of the properties of the paternal family, but compassionate cannot be considered as a property of her deceased father. There is no uniform definition of family and varies according to the purpose. The definition of family for family pension under DCRB scheme 1981 is different from the definition of availing death gratuity. The modern definition of family in sociology is two or more people related to birth, marriage, adoption, residing in the same housing unit. The government is pleased to make the West Bengal scheme for compassionate appointment 2013 in it should be supersession of all previous orders in this respect to resolve the issue of compassionate appointment, and the same published as notification 251 EMP dated 3/12/2013 under the provision of the scheme regulating the appointment on compassionate. The definition of dependent family member means spouse, son, including legally adopted son before the death or incapacitation, or unmarried daughters, including legally adopted unmarried daughter before the death or incapacitation. Yes, this is important. Married daughter who on the death or incapacitation was unmarried. So had it been the case of the petitioner that she has been deserted, widowed or divorcee, her case would have fall under this definition of family within the meaning of 697 or this compassionate scheme. Brother or sister also, but death not important, who was wholly dependent on the government employee at the time of death in harness. And I'm on the next page. Who was wholly dependent on the government employee at the time of death in harness or incapacitation, as the case may be, and is in need of immediate financial assistance at the time of making application and also at the time of consideration. This instant case petitioner got married in 2011, that is 8 years prior to her father's death. Hence, her claim of compassionate appointment cannot sustain under the appropriate notification. The scope of employment on compassion is a scheme where a dependent family member of an employee, well, this part is important, where a dependent family member of an employee died or medically incapacitated while in service, and as published under notification 697, when a teacher or non-teaching staff dies in harness before the death of his or her superannuation, leaving a family which is in the opinion of the DI in such extremely financial hardship that it fails to provide 2 square meals and other essential to the surviving member of the deceased teacher's family. That is important. That is the spouse, son and daughter of the deceased teacher or non-teaching staff who is possessing requisite qualification. This particular petitioner has qualification, but she has not family member of her parental family by virtue of her marriage and got unemployed. Thus, the petitioner is not eligible for appointment compassionate ground for premature death of her deceased father. The surviving member of the deceased teacher are his widow, Kapati Mondal, son Devraj Mondal, having required educational qualification, would have prayed for compassionate appointment, and records reveal that they are in extreme financial hardship, but they did not, and hence out of zone of consideration for compassionate appointment. Thus, the request has forwarded by the chairman by this person are considered and found the petitioner being married daughter is not eligible for compassionate ground under the provision of aforesaid notification. May I just add one that compassionate appointment, as in many cases it cannot be taken as a matter of right. To meet up the immediate necessity of the family for its immediate survival, it is meant for. Not that it will pass on to other family and it will thereafter it will be continuing as any hereditary. So had it been my case, I have already submitted that dependent. Had she been
But where is that inquiry that she is not dependent on the father?
That is nowhere it has been submitted that she is the dependent
But
upon
your
the father.
inquiry does not also reveal that.
He has
District
not.
Inspector also has not done that inquiry.
Well, he has categorically stated that it is dependent means after
No,
divorce.
only on the ground that she has become a part of another family will not make her independent. You have to come to a finding that she is a dependent or not.
Dependent means what we have, my lord, that had it been this widow or divorced daughter.
Your answer to the definition of dependent is that she must be a part of the family. If she is a part of some other family, then she is not a dependent.
Even for
this
the
logic does not follow.
Yeah, no, my lord, even for the family pension in favor of unmarried or married daughter, it has been granted. Unmarried or widow daughter. The question was that whether the pre-81 before coming up of DCRB 81 death cum retirement benefit 81 prior to death the spouse was allowed. The question was that whether this unmarried or widow would be entitled to get this family pension. That has been by the special bench of our High Court. It has been held that yes, like since this post 1981 deceased employees unmarried and widow daughter are getting, so it has been extended to them also. Here, if we follow the same principle, that widow or divorced daughter, that comes to be a dependent daughter of a deceased employee. But in case he is married, that too.
Where is her application for compassionate appointment?
And DI have.
Where is her application for compassionate appointment? Mr. Bhattacharya, where is your application for compassionate appointment?
But my first application is at page 29.
29.
29.
Yes, page 29.
Yes.
It was first mentioned by my mother, Topati Mondol, 7th of May 2019. Then your lordship will find page 31. I made it on 3rd of June 2019. The Bengali portion is page 32. And the sub-inspector of schools, kindly see the note, left bottom. The sub-inspector of school says that the prayer for job, Lordship got it?
Page
32.
Yes.
Left hand bottom. Prayer for a job of Rimpa Ghosh, daughter of Swanso.
Forwarded
to the chairman of the DPSC. I have a very short prayer. My case was considered by the High Court twice. Kindly see Justice Tapabrata Chakraborty's judgment once. Directing
where?
I tell you. The first, may I get the query from the court that as my learned friend has placed before your lordship that the married daughters, they don't have a right on employment. Your lordship is aware of the special bench judgment which I have annexed here also.
Yes.
Purnima Das's judgment delivered by the author of the judgment is Justice Datto, page 48 onwards. Where for the first time at paragraph 113, the special bench has held that 113. Paragraph 113 kindly sees, consequently, the offending provision of the notification dated April 2, 2008, governing the case of Orpita and Kakuli and February 3, 2000.
Paragraph 113.
Yes, page 107.
Yes.
Consequently, the offending provision of the notification dated 2nd April 2008, governing the cases of Orpita and Kakuli, and February 3, 2009, governing the case of Purnima, that is the adjective unmarried before the daughter, is struck down as violative to the constitution. What more?
Yes.
It, however, goes without saying that
he had to consider it independently whether the daughter was entitled to compassionate appointment or not.
May I complete it?
Of that.
May I complete it? Well, your lordship, I have hand over one judgment of Justice Amrita Sinha.
That was on a different ground. That was where
this ground has also been taken by the DI.
But that was not the ground on which the judgment has been set aside. The judgment has been set aside on the ground that pension and all this is sufficient for this court. But that judgment turns on a different footing where pensionary benefit was taken into consideration to annul. That is not your case.
That is my case also.
No.
Kindly.
DI has only gone on this basis that you are a married daughter, therefore you are not entitled. Rather,
No. Probably I'm not clear to your lordship.
No, you are absolutely clear. I have read the order. No more clarity is required. DI has said that you are
page 152.
You are not a member of the family. And rather, DI has said that your other members of the family do have requirement, but they have not applied. That is what the DI has said. You read page 152.
Yes, well, I'm on page 152.
Yes, read the penultimate paragraph. Thus the petition. Read that.
In this particular. Thus the petition.
Thus the petition. Yes. No, please read this.
Very well.
Your
thus the petition is answered. Petition is not eligible for compassionate for appointment or compassionate ground for premature death of her deceased father. The surviving member of the deceased teacher are his widow Tapati, son Debraj. Having required qualification, would have prayed for compassionate appointment, as record reveals that they are in extreme financial hardship. Yes.
That they are in extreme. Therefore, if they had paid, I would have granted. Is the meaning? Then thereafter,
but they did not. And hence, out of the zone of consideration for
because you have not prayed, that therefore they are not giving, and the daughter who has prayed is not a part of the family. That is the whole and
only one paragraph, short paragraph. The scope of employment. Kindly consider that.
Which paragraph? Yes.
Top two. Yes. The scope of employment on compassionate ground is a scheme where the dependent family members of an employee died on medical incapacity while in service, and as published under the notification number so, when a teacher or non-teaching staff dies in harness before the death of his or her superannuation leaving the family, is in the opinion of the district magistrate is such extreme financial hardship that it fails to provide 2 square meals and other essentials to the surviving members of the deceased family, that is the spouse, son and daughter of the deceased teacher and non-teaching staff who is possessing requisite educational qualification as laid down in Schedule 1 and the remained unemployed. But this point was considered by Justice Amrita Sinha. That this cannot be.
That is not the ground on which he has turned down. He has turned down on this ground.
Yes.
That you are a married daughter.
But I leave it to Lordship. But I made a judgment of this.
We have also not, my lord, come up with the argument that the married daughter will be wholly, my lord, will be out of the zone of consideration. Here, my lord, the Purnima Das, with this one holding its field, paragraph 111, 111 at page 106 also.
No, but you have relied on the same notification, haven't you?
Yes. No, this is the judgment of Justice Dotto in Purnima Das. That also says when paragraph.
No, but you have to inquire whether.
That is not the case of the petitioner herself.
Petitioner says that she wants job.
She wants job.
So
she has never come up with such a condition that she is being.
The chairman of the DPSC has forwarded my name.
Yes, that forwarded only cannot accrue
no.
right.
Yes, my right has been accrued. Kindly see the order of the DPSC chairman.
Under what?
He is also your office. You are holding
Mere
the
forwarding, we can.
no,
just
not mere
forward.
forwarding. And this is the order of the DPSC chairman.
My lord, just only one paragraph, page 106.
First it is
Just
reasoned order,
Purnima Das,
page 118.
Yes. Just
Hmm.
Purnima Das. Also, my lord, the situation was that. May I just come up with this fourth paragraph, starting with the restriction.
Page 106.
106, paragraph 111.
Yes.
The sentence starting with the restriction.
The restriction on married daughters.
Daughters being eligible to apply and to be considered for compassionate is likely and has in fact given rise to a legitimate grievance in the minds of married daughters who unfortunately are not looked after by their husbands. Purpose has to take shelter in their parental maternal home, survive on the benevolence showered by the fathers and mothers. This is the situation under which can be.
No, Mr. De, you are saying that is all right.
Without inquiry.
But you see what the DI has said. Yes. DI has simply gone on the basis that she is not a part of the family. The whole case set up by the DI is that family is one unit which comprises of father, mother, son, daughter. Once the daughter is married, she becomes a part of a different family. Yes. She is no longer a part of this family, which was taken care of by the breadwinner who has died, and therefore, having become part of a different family, she will not be entitled to compassionate appointment. This is the whole background.
To some extent, this inquiry, what is falling from Lordship is there. This very first paragraph of the DI's reason order. This document, page 151, the petitioner executed an affidavit. Page 151. Yes. First class judicial magistrate at Durgapur, wherein it is record petitioner is residing at this is her matrimonial house.
Very well, but that cannot be a ground. That cannot be a ground. There is one more thing which you come to page 152.
My lord.
The third paragraph from bottom. In this particular case.
In this petitioner has
last 3 lines you see, and yes. Not unemployed. Where does he get this? Where does he get this from? That the petitioner is not
in this
unemployed.
Particular case, the petitioner has the call, but she is not a family member of her.
And not unemployed. That means the petitioner is employed. Where did the DI get this from? So this also has
case DI has
page 118.
This particular
Kindly at page 118 once. 118. The chairman of the DPSC.
This shows that the DI went into this, whether she was employed or not. Then this is unreasonable.
Wrong observation.
And not only that.
That means she is employed somewhere. That would have been a good case.
Might be DI has got some.
Yes, then let him spell that out. If he spells that out, then in any case she will not get employment.
Yes.
And not only that, only one thing. Kindly page 118. Can you have a look? The chairman of the DPSC, while considering the order of Justice Tapobrata Chakraborty, had said, page 118, last paragraph. Accordingly, considering all the facts and circumstances, the undersigned is satisfied that Rimpa Ghosh is eligible to get a job as a non-teaching staff of a secondary school, and hence, as per Geo number Swenso, it is offered to send the application of Rimpa Das to the District Inspector of Schools, AC Purva Bardhaman. Are Baba. For their necessary consideration.
Let him reconsider.
Then,
yes. The petition.
For the state one.
74 Mr. Kamlesh Bhattacharya appearing. Please engage another court.
Not today.
No. Then
My lord, in this matter, Mr. Orko Bhattacharya is appearing. He is not came to the court due to his personal difficulties. So kindly make it not today.
Not today.
76 not.
For the state.
I am for the private respondent. As per your lord's
My lord,
objection, lord's
To
objection, I am
yesterday, my lord, they have served the opposition, my lord. The report, my lord.
report.
Report, my lord.
Yesterday, sir.
I have to take exception to this report, my lord. I am playing 7 days time, my lord.
लिखे नहीं.
And I am the petitioner, and pursuant to your lordship's earlier order, I have served upon the respondents once again.
Dr. Pastor is appearing on behalf of the Central School Service Commission. He is engaged
Only for consideration of my transfer application, my lord, nothing else. If
Only for consideration of his transfer application.
this is a school where I am the only non-teaching staff, there is no teaching staffs. There are no teaching staff. This was not the situation at the time of filing of this petition, but this is the present situation.
All right, not today. Let him come. The affidavit of service to Feruddin.
Lordship, Shantanam Kumar Mitra is appearing in this matter as state respondent. He is engaged in court number 5, so I am praying for not today.
Kindly see the order of the DI. Other day they took time. Other order is there. Suffering since 2022. Kindly see the order of the DI. Without
If not today is prayed for, Mr. Biswas, what will I do? Tell me. Not today. Chalo.
at least instruction could have been given.
Yes.
So that matter can be proceeded. Kindly take note of this.
अच्छा
This
ठीक है
type of
आगे
matters-
डाकू ना एक बार हाँ
अच्छा टाइम हो not today. Oh, अच्छा 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 Sorry, my lord, I could not get your lordship. In terms of your lordship's earlier order, I have served upon the non-appearing respondent. Kindly
time to take instruction. In the last
already was there is a direction. My lord, kindly take page 62, the impugned observation of the DI. Gynecological disorder mentioned. Now the authority says it is not the enlisted disease.
Where is he? Which court he is in?
5.
Pass over karo, Ashish. I am waiting. Let him
Passing
come.
it over.
Let him come. Let him.
If both parties are there, if both parties are there, please
Oh,
mention.
আমি
Passing it.
চারটের আগে তো নিশ্চয়ই আসতে পারবে। Let it be passed over. I am waiting. Can be maybe disposed of.
Yes.
Much obliged.
Item 17, I'm appearing for the petitioner, my lord. This is I'm led by Mr. Ujjwal Rai. So in this matter, my lord, the transfer application was made on the ground of distance primarily. That was first rejected by the school on the ground that the petitioner is a single teacher. I thereafter applied again on 20th August 2021. Thereafter, also the application is till date it is pending before the school. As per previous direction,
Yes.
Only my lord, single teacher, my lord. For the post of chemistry, one teacher is there, no other teacher. If your lordship direct, I give no objection. I will not responsible for a student, my lord. My lord, because there is no any teacher, my lord. Not a
No, you will have to act according to the rules. I cannot direct or you cannot withhold on your own. What do the rules say?
my lord,
See
I'm
the rules.
covered by a decision of this of your lordship, my lord, Shomir Das.
This is the top pattern, my lord.
The rules say that you have to forward it to the DI.
Yes.
You can't keep it up
Yes,
to
my
yourself.
lord, forward, my lord.
What was the
Because
what
this
was
was
the rule?
my 2015 rules. The page number is page 1 to 14 is the relevant rule, my lord.
Yes.
I shall forward the same, my lord. Within add your
The
lordship.
procedure is at rule 6.
Total position.
Yes.
And 28 August, August 2021, application was made. And it's pending before the school.
Yes, as
Considered in accordance with the
Yes, ma'am.
And this is prior to that, na?
prior to the amendment, my lord. Prior to the amendment. The amendment took place in 8 September 2021.
And this is August
20th August.
Show me that judgment.
Yes.
Your lordship has passed it.
Yes, it will be easier for me.
Page 108, my lord.
Sir,
Thank you, lord. Thank you. My lord, paragraphs 9 to 13, those are the relevant paragraphs, my lord, where the retrospective effect, there is no retrospective effect of the rules. Having heard, my lord, paragraph 11.
Yes, take down.
Yes.
So I have not said that the district inspector of schools will in all cases forward it. He will also test your eligibility in terms of the rules. WBC commission will also test your eligibility because
Lordship,
only on this ground it won't go.
follow me. Follow you.
এগুলো সব রেখে নিন এখানে অনেকগুলো আছে 1 2 অ্যাফিডেভিট অফ সার্ভিস ফাইল তিনখানা ডকুমেন্ট আছে তিন সবই থাকে
Passover Madam Mitra has come.
very well
I have been threatened to call him now.
But we are for the state respondent. But presence of school authority is very much negative. Presence of school authority.
Now, my lord, kindly see the action of the DI at page 62. Petitioner's wife is the patient of gynecological disorder, made the application on medical ground. Now, it was sent to the school, district inspector of school SC. District inspector says it is not the enlisted disease.
Madam, kindly see the remarks column, page 62.
yes
And your lordship kindly have a look at the my instructions. It in instruction, it would be clear everything, my lord.
No need of COMH certificate for spouse have any serious illness.
Yes.
No COMH remarks.
This is the
After the medical board disease, the patient is not enlisted. So, DI.
Paragraph number 3, your lordship kindly look.
Nah, it is the DI has made his own opinion without sending the matter to the COMH and report from the
no the instruction says that the CMOH has in the Utshosri portal given a remark saying that the disease is not enlisted.
Kindly see page 55.
Page 55.
Column number 6.
Yes.
Gynecological disorder.
But the CMOH, if the CMOH opines that it is not there, then merely because the petitioner says it will not be there, what is the CMOH's opinion? That is important.
That has not been sent. Kindly see.
That is paramount consideration and also
Kindly
not
see
in terms
the
of
remarks
relevant
column.
rules.
Remarks column.
Where is the CMOH says, where is that remark of the CMOH?
That is my case.
You bring that on
DI
record.
himself made this. No CMOH certificate is required. From where he has got?
Yes, that is important because unless the court sees that there is a remark by the if the CMOH has made such remark, then in that case we have no case.
Well, this is the remark of the CMOH which has been
No,
mentioned.
this is reflected by the DI, but
DI.
where is the remark of the CMOH?
But if your lordship so wishes, will
Yes, definitely it has to be brought.
46 rule 46 page.
I have understood. Let the CMOH come on record. Let us see. The petitioner is aggrieved by Not today.
I am for the petition. I have given notice, my lord. Notice I have given to the respondent authorities. I have given notice of the proceeding. This is also a transfer application. My transfer has been rejected on the ground that there are seniors in respect of the same school who also wants transfer, so they have to be preferred, and I should not be preferred, although the rules do not say so.
Serve a notice, file affidavit of service, will take. আর affidavit of service টা রেকর্ডে থাকবে। Not today.
Yeah. Here again, this is an application for transfer. This it was forwarded to the DI, but the DI has rejected it on the ground that after verification, school authority should send phone number of applicants in senior in age basis as per GT rules. Total teachers phone numbers as per 10% norm. My lord, this is my lord shall find this ground for rejection.
Lordship.
Oh,
Lordship, HON'BLE is appearing on behalf of the state, Lordship. He's engaged in another court, Lordship, praying for not today.
my lord, only one humble request, my lord. May a report be called for from the school, from the DI, my lord. But in his absence, if that direction could be given.
But DI has, what will he say? He has already said that it is.
On page 32, you not trying to do column number 2.
Yes.
This is the application 5th February 2020. This is the petitioner's application. Now,
15th February.
Yes. And it has reached the school. And the school has said the application is not among 10% of total teachers. So,
Yes. Yes, school is required. Yes, Mr. Chakraborty, not the DI. School is important.
Yes, my lord.
School is important. You have served the school?
Yes, my lord, I have served. There was direction upon me to serve. I have served. This was 24th June. The forwarding letter was.
What to do? School should be here. এটা ফেরত দিয়ে দিন।
Sir.
DTDC. Mr. Chakraborty serves
Fine.
through speed post. This courier
Sir,
service.
Speed post.
Affidavit of service filed today is taken on record.
I am for the petitioner. Last occasion, your lordship was pleased to direct me to serve notice on I have served and filing affidavit of service in this regard. The earlier affidavit of service.
What is this?
Matter relating to
kindly speak.
interest on gratuity matter.
Clause 2 and 3, my lord. Sent by EI, my lord.
A model order is there. Petitioner was an assistant teacher, my lord. He was only the delay period I am paying, my lord. Interest. না এই মুহূর্তে নেই দিয়ে দেবো।
You show this order to him.
My lord.
Because this delay is not because of the petitioner. Delay is because of the school authorities and the respondents. So he is entitled to interest. If delay was on account of the petitioner, then in that case we could have said that he is not entitled. Retired person is not getting the খালি একটা জিনিস রেকর্ড করে নিন এই অর্ডারটা রেকর্ড করবেন
Lord, the 85, I'm for the petitioner. Lord, the learned advocate Mr. Shantanu Mitra appearing for the state with his junior, my Lord, the Mr. Kino, Mirzafur Rahman, Mirza Kamaruddin. Lord, unfortunately, he died day before yesterday. My Lord,
Died? When?
Day before yesterday, my Lord, so another junior may be engaged with his.
I am adjourning it then.
Yes, Your Lord. Can you adjourn for a moment?
For next week, Your Lordship.
It is submitted that
I appear for the petitioner. And on the last occasion, there was direction to serve upon the non-appearing respondents. And we have not been able
somebody
to.
is appearing.
Yes.
What is?
You are
What
appearing.
is statement? By some.
The school is required, my lord.
School is
because-
required.
Yes.
Very well.
If it could be adjourned for a week, we shall get it done.
It is submitted that अच्छा all the respondents করে দিন non appearing নয় because some of them are appearing so it's not non appearing anymore.
My lord, in 87, Learned Senior Advocate Pratik Dhar is appearing for the Madrasa Service Commission. My lord will kindly fix it on 24th of July.
I am adjourning it not today because it will in any case come when it comes next day you
Or three matters.
no, unnecessarily adjournment order. How many orders will I pass for adjournment unnecessarily?
I'm for the state respondents. my lord.
Not today.
And my lord, I am paying for only not today, my lord. The radio is appearing.
Not today.
My lord, I am for the petitioner. My lord, Mr. Soumen Chatterjee, led by Mr. Shopun Banerjee, is appearing for the state.
And
My lord, this is the matter, my lord, regarding payment of higher pay scale, my lord, after enhancement of the, my lord, the educational qualification.
oh, what is the reason for non-grant?
My lord, actually, DI is sitting tight over the matter from the very beginning, in spite of repeated
He
correspondence.
has not decided it as yet.
My lord?
DI has not decided.
No, not yet decided, my lord. Your lordship can direct and dispose of the matter, directing the DI, my lord.
If they were present, it would have been
My
easier.
lord, my lord.
Can you serve a notice on them?
Yes, my lord, I will serve and come back on Thursday.
Very well.
Because over telephone, I informed them that the matter is appearing before your lordship. but actually somehow they are engaged somewhere.
Not today.
Not today, but tomorrow I am some personal.
You pray, I'll give not today, tomorrow also. Not a problem. I don't, I mean, I don't refuse adjournments. If it is for a genuine reason, you pray, I'll
Day
grant.
after tomorrow.
Unnecessarily, I will have to indicate this, that, let it be tomorrow.
I have no
Tomorrow
objection,
you
madam,
make.
because madam, I have already granted madam, no objection certificate madam, in favor of the
To
petition.
what?
Regarding transfer madam. Transfer madam.
I don't know his case. Yes. Call Kurun.
I am for the petitioner, my lord. And as per your lordship direction, my lord, I have served the notice to all the respondents, my lord.
He is appearing.
Yes. My lord, petitioner before your lordship with prayer for enhancement of salary, my lord, due to my lord, higher study. My lord, petitioner.
Then state is important.
My lord, I have already served the copy, my lord.
Very well. If you have served, therefore I'll take it up ex parte. That is not.
No, my lord.
Actually, pay for a higher scale of after enhancement of the qualification. So now the school authority has already forwarded all the documents.
Your role is not there. State has to be there.
My lord.
Otherwise, district inspector of the
Yes, yes.
You don't know who is appearing.
জিপি অফিসে গিয়ে জিজ্ঞেস করো কালকে
দিয়ে দিস সব
keep it ফিজিক্যালি গিয়ে জিজ্ঞেস করো নাম কার নামে আলো
keep it on 17th, my lord, then I will inform the matter tomorrow.
You have not served the GP.
No, my lord.
Where?
My lord,
no, GP service.
You have not served the GP. That is why they are not appearing.
Yes, yes, my lord.
Then, and you want me to take up.
My lord, I have some state and GP. No, sorry.
Normal super my qualification is this GP heading is there. My lord.
Yes. My lord, GP has not been served, my lord.
Yes. Serve the GP. Serve the GP.
My lord.
Service upon the state respondents.
Direction to serve the school authority. I have served.
They are appearing.
Lordship, this is a transfer application. It is backed by the headmaster of this school on the ground of single subject teacher. Kindly consider page number 24. Without considering the
Just a minute, madam. Services wrongly affected, madam. See what you have written.
oh, Lordship,
It is not before this court.
Lordship,
So he may have
I will
slept.
serve.
The petitioner shall serve a notice
My lord, I am for petitioner. My lord, petitioner paid for transfer on general ground. His application pending before the head of the institution.
not even served once.
Yes, occasion already served, my lord.
When? 2022.
2024 December.
Recent. When?
December 2024.
Serve again, serve again. Without service, I will not take. If both parties are there, I am willing to take any matter, but not ex parte.
My lord, can you direct on serve?
The respondents are not represented. Full stop.
Lordship was pleased to direct me to serve notice.
Nobody is
I
there,
have-
not today.
nobody
2
is-
minutes left, 1 minute left. No use.
My lord, I am for the petitioner. My lord, there was an allegation against the petitioner. The criminal case is pending. My lord, in such criminal case, petitioner has already been acquitted. But just few days earlier, my lord, I have received the certified copy. Kindly allow me to file a supplementary affidavit to bring on record that judgment.
Very well. Mr. Bari, learned advocate, appearing for the petitioner. Thank you. ছেড়ে দিন, আমি উঠে যাই।